Tell you, if you want a really good water rights lawyer, Katie's the one. She's got excellent. Got a good background, native title.
Hello everyone, and welcome to our final NELA webinar for the year, which is looking at environmental decision making, Indigenous knowledges in environmental decision making. My name is Dr. Michelle Lim, and I'm a NELA board member, and it gives me immense pleasure to introduce Taylor Clarke, who will acknowledge country. Thank you, Taylor.
Thank you. Tiari mara, waramarigo daraga pemo, warami mitiga gurambarak didgerigo. I'd like to acknowledge that we're meeting on the Waramarical lands of the Darug Nation. I'm very proud to be here. We believe in coming together like this to learn from one another. We believe if we can't do this, there's no way we can move forward into the future. I pay my respects to my elders here with me today and those that we continue this fight for, who've been fighting for generations.
Thank you, Taylor. And I'm really excited about the panel we have today. I've been given the task to introduce Judith, who will be hosting this session and will be introducing each of the speakers in a lot more detail. But Judith, to many of us, requires no introduction, but I'll give one all the same because I'd like to highlight some of the very important work she's been doing recently and also across her illustrious career, which includes not only assisting in setting up the Environmental Defender's Office, but also since 1982 working on Indigenous issues and continues to work in the education space, but also in terms of bringing people together in discussions such as this. So thank you, Dr. Judith Preston.
Thank you, Dr. Michelle Lim. I feel a bit humble. What I'd like to say is that my knowledge is developing, and it's the people in the room here that contribute to this discussion that I feel humbled to be with. So I'll introduce Phil Duncan, who's a Gomeroi Wiradjuri man, who's the chairperson of Murray-Darling Community Consultative Committee. What a mouthful, and an applicant on his community's native title claim. He's presently working for Alluvium. Anything to add to that?
No, that's fine. We'll keep it short.
Okay. Taylor Clarke, who just did the acknowledgement. She's a Macquarie law student, but she's also a Gundagara woman, and her mother, Kazan Brown, is also a Gundagara woman from the Warragamba area. And they're both involved in a campaign about the dam wall raising of Warragamba Dam. So we're going to hear about that, their work. And Professor Donna Craig, who has been working at Macquarie University, but she's now at Western Sydney University, and she's had a lot of experience in the intersection between Indigenous and environmental justice areas. So I'm very honoured to have you all here. This all started from something I did in my PhD thesis, which is to consider that Indigenous knowledges, the breadth and width of what that means, are not really considered, in my opinion, very well in environmental law, particularly at national level. We have some, exceptions, like in Victoria, there's some very good legislation and programs happening there, but generally speaking, I think there's work to be done. So I'll just go to a very quick PowerPoint. I think we do some slide sharing or something. Oh.
Work. There we go. Is that the first?
Yes, but we need to maybe move that out of the way.
Yeah.
Okay, it's just, I know there's a lot of environmental lawyers amongst you, but just to recall for those of you who aren't, that environmental law is generally about guiding government decision making for the objective, in my opinion, to protect natural resources and cultural resources. It's increasingly become interdisciplinary and it's integrated into the socio-economic and cultural governance. Just let people know. Okay. So basically, the knowledges that feed into environmental law and processes are preferencing science and technology, and there is a lot of very good work around the globe, which is about including extended knowledges, which includes Indigenous knowledges. I mean, it can also include local knowledges as well, into biocultural assets and ecosystems and their services. But law provides a framework and process for regulating these objectives. Are we able to get rid of because it's sort of, you know,
Yeah, we close that.
or can we, yeah. Okay. So with law and governance, part of the development of environmental law is that we have processes that are accountable, open, transparent, and include public participation. So environmental laws essentially can either create or deny voices and participants of all the stakeholders in the environment, which includes Indigenous people and their knowledge custodians and the environment itself. As I said, environmental law often prioritises science and technology away from Indigenous knowledges, voices and values. And also, I'd just like to make the point, and this is my own point and shared by a few people, that you shouldn't assume necessarily that environmental and Indigenous interests are always intersecting, that sometimes environmental protection objectives like wild rivers, wilderness, national parks actually conflict with Indigenous peoples. You know, they can be excluded from country, they can be excluded from the process of managing these areas and excluded altogether in wilderness areas. So people can be hurt by decisions that seem incomprehensible. Now I'd like to open this YouTube clip. I will do that. This is just, I mean, all of you have heard about the Duncan Caves disaster, and I just wanted to run this little video that shows you. I'm sorry, it includes some ads.
This is one of the caves you see visually. Further to the left, there's the two caves completely covered by levels now. They done anything wrong. They took a lot of the earth. We've done a hard work over years. These things before. What they've done here, everything went.
I think people are having trouble seeing the video.
All right, we might just move on then. How do I get back to the
Click on the,
Down the bottom.
yeah. Yeah.
Right, okay, back. So just, I mean, apparently no one can hear that, but if you click on the Guardian article about Duncan Caves, it's made to make the point that this process closed out a lot of the Indigenous caretakers of that site. It's actually very emotional watching that, and so I would urge you all to have a look if you can. So in terms of knowledge and practices derived from place-based observation activities on country, it's done through access to non-Indigenous land and waters, because often country is excluded by pastoral leases, mining, national parks, that sort of thing. So the stories are passed through songlines, trade routes, ceremony, songs, artworks, and they even have, there's many examples of community exchange. I mean, there's another, I won't worry about opening any of the links I've got there, but this is just to lead you to an article that talks about Victor Stephenson, who's an Indigenous fire practitioner who went across to Canada and worked with First Nations people there. So, I mean, that's just one of many examples. So just the differences between Indigenous knowledges, the process and the objectives. Indigenous knowledges passed orally, sometimes written down to appropriate community members by elders through storytelling, songs and ceremony. Sometimes locally based, but there are strong inter-country links. Whereas Western science and technology are based on experimental data retrieved from rigorous work, and usually based on academic credentialed persons, so-called experts. So there's great differences in the approaches, but gradually Indigenous knowledges are using the best of both worlds. So at the international level, you've got a number of international legal instruments. I've just listed a few there that consider the importance of the application of Indigenous knowledges. So in a longer version of these PowerPoints, I've set out the number of areas in these instruments where Indigenous knowledges and custodians are prioritised. But needless to say that importance of Indigenous knowledges and custodians is well established at international law. The thing is, it's no good being at international law if you don't implement it at national level through laws, policies, and governance. So that's the thing that we've got to do. Things like putting Indigenous knowledges and the value of custodians into objectives, but also into duties for decision makers. And you have to include reviewable processes. So if there's not shown to be a process for decision makers and whether they've considered relevant knowledge or relevant knowledge holders, then there has to be an easily accessible process for people to review that decision. And also to have things like no orders for security for costs, open standing and protective cost orders like Land and Environment Court and the Federal Court has some of these processes as well. So environmental decision making has become increasingly complicated, but I think that it can only value add to have Indigenous knowledges, the relevant Indigenous knowledges and custodians included in the process. And I think there should be an assumption that there is such knowledge and custodians available and that people have got to use the right processes of finding that knowledge and also use appropriate processes, protocols to go about consulting, not just find one person that says, oh yes, I speak for everybody and it's all good. So in terms of just a few examples at the national legal framework, the Epbc Act is one example. It does have sort of prioritising Indigenous knowledges in its objectives, but there aren't any specific legal duties for decision makers to consider that knowledge in environmental decision making. They have a number of committees and some of the committees have actually stopped being around. There is an Indigenous Advisory Committee which represents Indigenous interests, but its role is advisory only. So there have been examples where this committee has suggested things and then the Minister may not take that advice. There has been things like the Indigenous Protected Areas Advisory Subcommittee and the Biological Diversity Advisory Committee with Indigenous members, but they've been disbanded. So in terms of the Water Act, which is another important national piece of legislation, there's a quote from the National Native Title Council saying, federal water law should include provision for the meaningful involvement of Indigenous people at all levels of water planning and management, from policy development and planning decisions to the operational processes that involve on-the-ground activities that manage water directly. Importantly, this should involve involvement of Indigenous people in this review process through further consultation and designated position on the advisory panel. And then bilateral agreements, like for example, the mining activity in Queensland. Section 49A says that the Minister is to consider the role and interests of Indigenous landowners and managers. Regulation 8A of the Epbc Act about genetic resources also has to consider Aboriginal custodians. So basically the Finkel Review has echoed this. It doesn't meet the aspirations of traditional owners for managing the land. National environmental standards should include requirements relating to best practice in Indigenous engagement, but whatever that means. I mean, there are a number of protocols around, maybe meeting the UN Declaration of the Rights of Indigenous People. There are good examples, but they've got to be written into the regulations of the environmental laws. So it's an embedded process. This is how you go about it. You've got to find the right people. So they also say that in Indigenous knowledge and Western science, their experts should be equal in advice to the Minister. But it says in advice, still getting into the in advice. I mean, we should be having some control, or my suggestion is more control over the process. So I've just posed the question that proposed Science and Information Committee is the new iteration of this, the Indigenous Advisory Committee, but I'm not sure we've progressed that far if it's still advisory. And then they've suggested that more responsibility for traditional owners to control input into joint management of protected areas. And we've got there is a huge program of Indigenous protected areas, but they are dependent on funding from the federal government. And there should be more, because there's certainly studies that have suggested that they're producing social and economic outcomes that are excellent. And then I just posed the question of the latest national park in New South Wales, Narriara. Why wasn't that proposed as an IPA? That's just my own question. It seems like it would be a good idea. Also, there's an excellent little excerpt where Victor Stevenson is talking about cultural burning on Q&A, and he says, you know, why aren't Indigenous people given the wheel? You know, why aren't they given more control over natural resource management? Excellent question. So I'm saying that you should be having truth-telling to acknowledge and eradicate colonial and racist-based laws, embed effective inclusion of Indigenous knowledges and voices of custodians in environmental laws. My thesis proposed some national legislation to, give effect to this. Consultation processes should be based on UNDRIP principles. There's a spelling mistake there, sorry about that. As well as Indigenous justice principles more broadly in Australian laws. Sami Parliament is a good example for a representative body. There's a few examples around the world for the treaties, and there's no doubt Makarrata Treaty is proposed. And then there's an example in Peru of the Wampas Autonomous Nation that I think is very interesting and powerful example that I think people probably don't know about. They've got an autonomous statute, and they basically have set up this body under this statute, and they have just asked the Peruvian government to deal with them, you know, on their own terms. So maybe this would not work in Australia, but it's certainly something to have a look at. And the other thing is perhaps an Indigenous ombudsperson more broadly. Now, enough talking from me. Perhaps perhaps Taylor might introduce your mother and tell us what you and she have been doing in terms of the Warragamba dam wall raising campaign.
Yeah, absolutely. I'll start by introducing us, but Mum, jump in if I miss anything. My name is Taylor Clarke, and this is my mum, Kazane Brown. We work together on the Give a Dam campaign, which is a campaign to stop the raising of Warragamba Dam wall. We've been working on this for about 3 years now, and it's mostly taken up our whole lives. But apart from it slowing down my university degree, we have to look at this as the fight of our lives as Gundungurra people. So we've pulled out all stops, made a lot of really great connections with people who have helped us on this journey, because what it comes down to is it has been a very corrupt process, and it has been very hard, and that's something we'll talk about a little bit later. But generally our role has involved talking to community groups, lobbying politicians, connecting with NGOs and environmental groups to raise awareness of the issue. Mum's done a lot of media recently. Generally what we're trying to do is share the story of our people as much as possible, because it is a story that isn't often told and has been like very quiet and under wraps for the last 50 odd years since the dam was originally constructed, because in the 1950s the Barragarang population of Gundungurra people were forcibly evacuated from the area to make way for the construction of Warragamba Dam. Because of that, our family has spread out across New South Wales, taking with them parts of their story, and it's been Mum's job for the past 30 odd years, and now my job as a 23-year-old woman, to be making these connections again and trying to find as much of our history again before it's possibly being destroyed. So that's our work at the moment. Mum, did you want to add anything?
No, I think you covered it.
Thank you.
And so the EIA process for this proposal has been a little bit fraught. I mean, it's sometimes over the years I've observed the environmental impact assessment documents are quite complex. They involve a lot of technical information. How are you getting some assistance? I mean, assuming, if I looked at the same documents, I would be struggling with the science and technology. So I naturally want to get somebody who could interpret the information and really help you understand what impact the raising of 14 metres will make on your country, the World Heritage Area, the Blue Mountains. So
I would say my answer to that is in multiple parts. To start with, we're part of a group of registered Aboriginal people of roughly 20 to 25 people. None of us have a legal background, certainly no science or archaeology backgrounds. And we came to these meetings together and were presented with these documents that are full of incorrect scientific jargon. And there was an implied privacy agreement that no one signed that's at a face value prevented us from getting any extra advice. We were facing a huge fine if we took the draft EIS or any of the documents through this process to get a second opinion. But that being said, I don't know how we could have possibly responded to the EIS without getting an extra opinion. So that has been very hard. Also, I would say, yes, the consultation has been fraught because the proponents of this project knew that the RAPs were unable to, generally speaking, understand this document. I don't know how to understand it, and I'm a university student studying the law, and I couldn't make any sense of it. They knew that, and yet they held a workshop where they offered to help doctor responses to the proposal. Now, I feel like that is just one example of how this is not an honest process. It's not a process where they have cared about consultation with us or any semblance of truth, no just outcomes. They want it to be as easy and quickly done as possible so we can get out of the way and they can move on with their project. we have been lucky that we have been able to work with a number of people who were able to provide extra advice. We were lucky that an archaeology company picked up the draft EIS in its early stages and were able to help us decipher it. And it has been found that it is scientifically incorrect, and that only a quarter of the area that was supposed to be surveyed in the EIS methodology was surveyed. So in order to meet the objectives that they set for themselves, the EIS really needs to restart, which we knew, but now we know is in this document. So I've got no confidence in this process, and I have no confidence that it is going to be done again, because they've shown no interest in that, and it's going to be a very expensive process. Do you want to add anything to that?
Just that the EIS, the draft copy that was given to us is all scientifically based. There's nothing in there at all about Aboriginal culture or Aboriginal people. It's very wrong. There's a paragraph in there that states Burragering, Lake Burragering would have been a fantastic resource for Aboriginal people. Didn't exist. Yeah, but Lake Burragering didn't exist until the wall went up. So by that time we'd all moved out and there was no Aboriginal people there anyway. There's so many problems with it. The woman who wrote the report spent one day out of 72 in the field and wrote the report based on photos.
Can I add to that as well? Mum just said of 72 days. Initially, didn't they only want to do it
They
for
only
30
wanted to do
days?
14.
Yeah, so we pushed and pushed, and even when it was extended to 72 days, they only got a quarter of it
This
done.
is a huge area. This is, and it's not flat ground. You're up and down, hills and in creeks, and it'd be a horrible place to have to walk over. And I give credit to the survey team. They did what they could in the time that they were given. And I think they did a great job considering the amount of time they were given. It's not their fault that this has happened.
But you need people to take the time to sit with the community, talk about everything that's important to them.
That's right.
Do it in the right way.
That's right.
Identify the right people.
Yeah. No one's
Spend
asked
time.
us what these sites are or what they mean or why they're there or what they mean to Aboriginal people in general.
So what we need is a fair process that assesses the impact, socio-cultural impact, as well as the physical implications of the proposal.
And this will have a huge impact on us. This is our songline. This is our, this is our main creation story, and they want to flood it again. They've already
It's
done
a story
it.
that happens a lot, not just in Australia, but many places in the world. That it's not rocket science to say if you've got assets, cultural assets, and people that are going to be impacted, whether it's Indigenous or non-Indigenous, you need to consider their interests and document them, tell them about the process, include their voices, and help them understand what the proposal is.
I think you've absolutely just summarised it, and it really should be that cut and dry. I'd also like to add that because Mum and I aren't part of an affiliated organisation or anything like that, we were left out of a lot of this process. They didn't just ask, do you have an interest in this? Is this going to affect you? Do you have knowledge? They wanted us to be part of a not-for-profit organisation and to have thousands of dollars worth of insurance and all this sort of stuff, and we don't. So Mum wasn't able to go down and do any of the field work despite having a lifetime of knowledge of these places. That also to me shows that they aren't interested in a just outcome. They aren't interested in truth. In an ideal world, I'd like it to be, as you've just said, that if you've got an interest and you're a stakeholder, they will make room for you, but it's just not like that.
And I did take the draft report and took it to some people to try and get them to help us, but no one would touch it because it wasn't a public document. So no one wanted to read it until it was public. And I mean, as far as I'm concerned, by the time it's public, they've made up their mind and it's too late.
Would you like to just say briefly, I mean, I've said a little bit about your background, but you're involved in a lot of water management. it's not all you do, but it seems that there's a bit of a theme going on here of inclusion of knowledge and inclusion of people in process. So you're the chairperson of the Murray-Darling Basin Community Consultative Committee. I'm quite interested to hear what that role is about and how that position you have, you're able to feed in your knowledge and your country.
Well, Yama going into Phil Naya, that's hello and welcome, my name's Phil. I'm a Gomeroi man, but I also have very, very strong bloodline connections into the Wiradjuri Nation. I'm very, very grateful for this opportunity. I think that there is, over the past 30 years of being involved in water management, particularly in New South Wales, going back to when there were 24 catchment management boards, then to 13 CMAs and now 11 local land services, we've seen a shift. We've seen a shift away from the appreciation of what they called back then traditional ecological knowledge. And for me, the way I talk and what I believe is we've transgressed that. It's not just traditional ecological knowledge, it's a way of life. It's an interactive way of life. It's our symbiotic relationship with our cultural landscapes. And for me, it's a cultural science. And I've been using that term for quite some time now. And Brad Mogridge, Associate Professor Brad Mogridge, University of Canberra, was the first to coin that. I think that there is a lack of understanding about this symbiotic relation, this cultural connection, both the tangible and the intangible, which is the invisible. I think that, I know that we operate from a deficit position continually. When we look at the 2007 Water Act, that only has to have regard for our cultural values. And that Water Act was drawn up to create the Murray-Darling Basin Authority and the Basin Plan. And again, I reiterate that we keep having to operate from a deficit position. And one of those problems with that is we only have the ability to plan for 4 years. Government of the day. And it creates a dysfunctional process for us to revisit or reignite or re-establish a different platform to go forward on. Therefore, for me, my nation, the Gomeroi, Gamilaroi, starts between Muswellbrook and Aberdeen and goes up to Nindi Gully just under St George. It transgresses that little thing called the Queensland-New South Wales border, and we come inside the Central Tablelands and the Great Dividing Range. We as a people, the Gomeroi people, we have 7 rivers, the Great Artesian Basin, and we have the Guida Wetlands, the Gingham Waterhole, which is an international Ramsar site. And we have continuously said under UNDRIP, or the United Nations Declaration of the Rights of Indigenous People, particular Article 19, you want to talk to us, you come without you need to do it without free, prior and informed consent. But we don't hold the purse strings. We are culturally rich, knowledge rich, asset poor. So our native title claim was significant when we first began that journey in 2007. And unfortunately, both with what is recognised in the Permanent Indigenous Forum of the United Nations as the most progressive act of any state for Indigenous people of the world, the 1983 Aboriginal Land Rights Act of New South Wales, and then the 1993 Native Title Act, we've had land decoupled from water. So therefore, any negotiations around what we as a people want to do in relation to our cultural landscapes, we have to talk about land here and we have to talk about water here. And it is so hard to connect the two with our cultural values, our cultural way of life, our cultural knowledge, our cultural science on how we interact with our cultural landscapes. And, you know, we have to go through these instruments of Parliament and government. You know, we identify Section 211 of the Native Title Act, which gives us access. Native title doesn't give you water, neither does land rights. Let's be very, very clear about that. It gives you the right to negotiate. It does not give you the right to water. And the other interesting thing that I observed in one of your slides is that we keep having to take on advisory roles. We are not masters of our own destiny. We are not masters of our own cultural law, LORE, and the customs that are associated with that responsibility to not just care for country, but to exercise our right, our cultural right to be involved in repairing country. So these are the type of difficulties we continuously face. Now, this new way of doing business systems thinking, well, you know, we as a people, I know my people, we think spatially, we think temporally, we think upstream, we think downstream, but we think about people. First and foremost, we think about our cultural responsibilities that have been gifted to us. They're not just gifted to you, they are earned. Your songlines in my nation, your songlines and your dreaming stories are not gifted to you. They are not a rite of passage. They are earned. And this can be different. This is the other probably dynamic you see between my wife's a saltwater woman, you and Walbunja, right? And I'm a muddy waters man. And though we share the same values, we are somewhat different, but I am learning and understanding more about, and this is this dynamic about only ever being able to plan for 4 years. So we now need to think about systems, thinking, and we're getting there. And I think one of the problems we have is a lack of champions. But having said that, Victoria, what a great outcome. Victoria just gave 2 billion litres, 2 gigalitres of water to the Gunai-Kurnai people. And congratulations to Troy McDonald, but that came about with really strong partnerships with, you know, with lawyers like Erin O'Donnell, Melbourne University, the Department of Environment, Land, Water and Planning, the Victorian Environmental Water Holder. They wanted to play a role in making a difference, and they have. And they have.
Well, that's the will. I mean, they also have Human Rights Act, they have Climate Change Act, and the Yarra River. Yarra River protection.
Yeah.
And there they've got a combination of custodians and government in a trust. It's I mean, you find it in New Zealand and India as well, these kind of new statutes that consider a partnership, and that's progress. I mean, that's how it should be, but unfortunately it's in the minimum.
But our people have been saying this, sorry Judith, but our people have been saying this for years. I can remember in the first real significant gig that I ever got to work with some really intelligent people that wanted to make a difference. The National Water Commission, and they established the first People's Water Engagement Council. And Donna, you probably remember this name. We as a council sat on the banks of the Catherine River with Uncle Bill Harney. And we had all the scientists, all the researchers saying that they're separate systems. And then Uncle Bill Harney said, the Mataranka aquifer. They were connected by underground water system called the Tyndale Aquifer. It's the Mataranka Aquifer that connects the Daly and that systems. And you know, this is the way, like if you go to my country, the Gomeroi, like I said, we've got this great artesian basin and then it's layered. It's not just the artesian basin, we've got bore water, then we've got this amazing, healthy artesian water, hot water springs. And then we got, so there is about 4 layers within my nation. And, you know, we face the, under our Native Title Act, under our Native Title Claim, you know, one of the things we're struggling to understand is the tick for coal seam gas in the Pilliga State Forest with another 836 wells to be countersunk. Now, if that damages that artesian basin, it is irreversible. And I have not seen any signs. I'm not a stupid man, but I can tell you this, I'm not an academic either, but I have not seen any signs or any research that tells me that once it's poisoned, it can be reversed. It can't be. So look, I've spoken a lot about that, but there is one plug that I want to give the New South Wales is about a very sound partnership with the Nature Conservancy, with Nimikara being handed back and Gaini. And for me, there are many, many, many successful APAs, and particularly in the saltwater country with the people where it was, where it was first kicked off. But to see something in the middle of New South Wales that we call our own kakadu, 200 and something different bird species, let alone, the regeneration of native fish stocks that are down to less than 10% since colonisation, I might add. And you've got the eel-tail catfish on the precipice of extinction. So initiatives like this are generated, and they don't come about by the instruments, they come about by the goodwill of people in government and strategic partnerships that want to make it happen. I know that's very political, Susan, but Judith, but it's something that I needed to say and I've been wanting to say for quite some time. We can't keep operating from a deficit position.
So we need to support truth-telling, whether it's truth-telling that people want to hear or not.
Truth-telling, we're hearing it firsthand. Yeah. We're hearing a life's journey. Yeah. And, as I come back to these assets, we are rich culturally, but we asset poor when it comes to putting on the wigs and the cloaks and the gowns to walk into an environment that is not conducive or understanding of our cultural way of life or our symbiotic existence with our cultural landscapes.
So, segue to Professor Donna Craig, who's a veteran, a warrior in this space. She's done work in Australia, but in Canada, United States, in Asia as well, about joint management models. I mean, you've done lots of other work as well, but relevant to Phil mentioned, and I mentioned Indigenous protected areas. That's one way of going about it. Can you tell us about some of the early work you were doing with, say, the Canadian First Nations people? Maybe then you can say something
I
about
think
that.
I have to really follow on from Phil's comment about you can't continue to proceed from a situation of deficit. You're all hard acts to follow. I'm a non-Indigenous person. I've been enormously privileged to learn and walk with Aboriginal people that I see my role as to serve those communities and operate according to their instructions. But I think part of the Uluru statement is a recognition to the fact it's not just truth-telling. That gets people's attention and recognises some injustice. But everything is relationship-based. If you're going to work in this space, and that's the reason it's been such a deeply enriching experience, because it's based on mutuality, trust and respect. And telling the story doesn't establish that. We have to rework these relationships. And I think one of the difficulties with an understanding that every Aboriginal nation is unique and specific, we lawyers like to talk about sui generis. And that was one of the aspects of native title that really blew apart, I think, when the government tried to legislate on it. When you recognise that every Aboriginal legal system and system of knowledge is unique and particular, it's very easy to divide and conquer. But there are principles that you can apply to the recognition of Indigenous knowledge and developing legal frameworks to empower that knowledge that can enable these customary institutions, knowledge holders, to become the decision makers. Now, how do we get there? The Canadian models, of course, are very much based on sovereignty and self-determination. You really only get decision making when you have a level of self-determination. So you have a title to land. You at least have joint management of resources. So under the Canadian Comprehensive Land Claims Agreements, they simultaneously negotiate self-determination, title to lands, waters, seas and resources. And there are a huge variety of different models. But there are, for example, in the Nunavut treaty arrangement, which was one of the very early ones, there are 7 co-management arrangements. And there's some of them with the Commonwealth government in relation to seas, some of them are with state governments or territory governments in relation to wildlife, some of them will be with local government in relation to planning. And part of the way that these co-management arrangements operate is a presumption that Indigenous knowledge or Indigenous science should be determinative. Because they are the experts. They are the people who live in that country year round. They're not people who fly in for 5 weeks in summer. And so, you know, it's an evolving process. One of the difficulties, I think, with federal joint managed parks, which is our main model co-management, is it tends to be frozen in time. And it seems to be simply applied to protected areas. It has to be applied to if you like, proactive development, as well as the conservation realm. If you don't have Aboriginal people involved in the environmental assessment process as experts and be funded as experts to prepare the documents and to critique the documents and respond, then what you're going to get is junk science, which is what you've got. So I think that, you know, the lesson of some of those experiences, it's an ongoing battle. But one way of trying to get from a reactive deficit position is to, in a sense, learn from the common law. The common law is constantly evolving. It was created as circumstances arose. This is long before we got codified law. And if you look at customary law, why can't that simply be asserted? Or the normative requirements for full prior informed consent in UNDRIP and the CVD, you know, we shouldn't wait for these rights to be granted or to be ratified and implemented. I think an Uluru Statement 2 could be an argument that these normative standards are the floor, that no Indigenous nation or group will engage without a recognition that these are the rights that should apply. And the experience in many other parts of the world is if these are uniformly and consistently asserted, it does become the law. You know, Canada was completely unwilling to engage or even use the term First Nations right into the 1980s. Until it was constantly asserted as the only political or legal relationship whereby they would engage with the government. So, I mean, I think, you know, you can argue platforms like that without saying, well, we're going to give you one uniform access or approach to Aboriginal law. What you're doing is largely applying minimum human rights and process standards, whereby you enable the appropriate people to be empowered to speak. So it's another way of thinking about how you access Indigenous knowledge and Indigenous political power. So I think that's another strategy that needs a lot more thought, because UNDRIP's been around a long time. And so does the CVD. And, you know, I always believe that power is taken, not given. And I think that there are customary norms coming from the bottom, and I think international norms relating to human rights and the specific rights of Indigenous people, if you like, coming from particularly the international realm, that can provide the floor, and that floor should not be dropped. So I think that's the contribution that people like myself can make. is to assist in that process. And I think that that may be a way of trying to work through the kind of institutionalised colonial powerlessness, which I think is to the deficit of every Australian.
Can I just jump in there? There's a couple of things that I wrote down there before you started talking that you just provided affirmation to me about, and one of them is that we can be better together. And, you know, we haven't got the resources. But language, water speak. In the water arena, where I'm operating in a $13 billion water arena at the moment, the limited amount of Aboriginal people, traditional owners that understand water speak is phenomenal. And so therefore it is left up to a couple of key people that do actually understand it, and particularly with academics like yourselves helping us with that journey. I'm not an academic. I'm lucky to get a school year 10 certificate, but I've been fortunate enough to be aligned with people like Judith, yourself, Brian. Anyway, I know it's a two-way knowledge thing. Yeah, I know that. But listen, I want to come back to this other thing about language and operating from the deficit position. If you look at Paul Keating's book afterward, his post-prime ministerial speeches, he talks about what native title was meant to do in his Redfern speech. That was then when he launched about the Reconciliation Action Plan. That was your licence to do business with Indigenous Australia. And in his larger oration about native title, he was surrounded, the whole oration was about social justice. It was about justice for Aboriginal people in this country. And then what happened? Change of government. And then we had a new Prime Minister, I'm not going to mention any names, and the whole Native Title Act was undone, was amended. So these are these continuous deficit positions, but I want to particularly touch on these type of partnerships that we need to have to demystify the language around water speak, legal speak, science speak.
Well, the process, being able to participate in the process.
Yeah, well, you know,
say what you need to say, because we're also, this is a voice opportunity for people, for you to put your point of view to people, the audience of NELA lawyers and other people who might be listening.
Well, I'm giving a talk next week at the Australian Freshwater Science Society conference on my own country where I'm hosting it, and my entire presentation is in my language. So you're going to have to look and learn, and I'm deliberately doing it to highlight the language and the deficit position. We don't understand how we're supposed to operate. Sorry, I just provided affirmation a couple of points.
So what I'm saying is it should be the power of assertion. Yeah, it's not a question of waiting for that power to be given. It should be asserted.
Yeah, well, sometimes it's hard to wait. Sometimes because you don't have enough Indigenous judges and magistrates making decisions that can give preference and voice to Indigenous people. So we need more of that. But also we can have policies like they do in New Zealand, where they have a lot of planning policies that and EIA processes where they're much more advanced, and I'll give you the information about that. We don't have that necessarily, but we have the social impact guidelines in New South Wales, so a huge step forward, but unfortunately only confined to big projects.
So it's a good point. Who are the land environmental courts and these courts? What are they doing to build their cultural capacity and understanding, and to have the next Indigenous judge, male or female? And the reason why I say that is because there's this whole other dynamic within Aboriginal society or Indigenous society in this country called men's and women's business. And a man should not be making judgment on cultural women's business, and vice versa.
They do have, I mean, I know, for example, with commissioners, and when they have had these issues come before the court, they do have custodians that come as court advisors, and they have commissioners, they have Aboriginal commissioners like Megan Davis, this one,
Look, that's fantastic that Megan Davis is a commissioner, but
but-
Megan is not a judge.
No, no, but she makes decisions as a commissioner in certain
Well, how many? Sorry, I'm not trying to be difficult, but how many Megans are there in the system?
No, exactly. That is the
So
very
the
good
pressure. I want to come back to these two women sitting opposite me. The pressure for one family, it can be debilitating. It can be send you into downright crushing, suffocating, and send you into the downward spiral of depression. And that just doesn't happen to one person in the family. The cascading effect, and then it gravitates out to the community.
trauma.
Transgenerational trauma.
Absolutely.
So
We won't put it on Taylor to be
Sorry.
the pathway to judicial appointment, but
why not?
obviously if-
Why not?
No.
That's what I'm expecting.
She
So,
may
Thanks, guys.
Certainly need more students studying law because it's a tool. It's not an end in itself, but that is one
No,
way.
it's not even the question of judges on the Land Environment Court. That is not a customary institution. You need something like the Watini Tribunal.
Yes.
And that should be built into every, adjudication arrangement, that there is a culturally appropriate tribunal in the way it's made up, but also in terms of the procedures that are followed.
I had the wonderful opportunity to sit with Uncle Badger Bates to talk about the barker. I don't call it the darling anymore. To talk about the barker being the artery, and if that artery is slashed there, right, there's no blood that gets to the body, being the Menindee Lakes in that system. That's how they talk. And you go out there, and there is a sense of despair, a sense of sadness from Broken Hill all the way down to Wentworth. And it's not just with the Indigenous community.
Well, I mean, the YouTube clip that I couldn't play showed some of the caretakers of the cave site saying that they let the old people down. I remember also that was the same sentiment in the McIntyre River when they want to expand the mine there. People are feeling a huge responsibility to protect and look after country, and if other decisions are made and they've got no control over it, it kills them, literally.
Well, mining and killed the tobacco industry around here. Ashford, we know that. It's a known fact.
Another way of looking at it is, that's a basic human rights, Indigenous rights perspective. Another way is to look at the future scenarios. If you look at the Murray-Darling Basin, you've got ageing old white people and a growing, a very, very substantial resident, long-term population of predominantly younger Aboriginal people. So if you're going to manage that system, the people who are going to manage it, who are going to stay there and who have an interest in managing will be Aboriginal. These old white guys will go and retire to the Gold Coast.
Well, if you look at a lot of the remote and isolated communities and villages, 90% of the population is Aboriginal. And for me, how we are not the mayor, how we are not the decision making in those towns, for me is unconscionable.
You've got to get a demographer on site.
Well, we've got to be encouraged to make our pen and our voice count.
Can I
We
just
call it
also,
Warrigal Garley, straight true water.
I just wanted to mention another example that's quite powerful, the Torres Strait Islanders, who are concerned about cultural heritage and intangible heritage losses from climate change impacts. And what they've done a little bit differently is the Client Earth assisting them in making a complaint to the UN Human Rights Committee, which is a name and shame kind of operation. It is a legal process, but in the sense that they'll make recommendations eventually, and hopefully the federal government will take notice. They've given them some money to help with, seawall construction, but I mean the intrusion of rising seas is disturbing grave sites, and to watch people talk about that is also incredibly moving, and you feel disempowered looking at what they're going through. Imagine your relatives are being literally washed away.
The Saibai people were the first climate change refugees, 1947. And the St Francis Assisi's Church, where the White Cross is, where they signed the deed of agreement to take up residence at Seisha in Bamaga, with the Bamaga people, Injinu, Yumajiko, Bamaga, who's the other mob? I can't think of their name, sorry, that's my fault. But you know, that cross marks the space where the place where that, it wasn't done with government. It was the Torres Strait Islander people of Saibai and the traditional owners from the Cape. And the traditional owners said, we will look after you. And now they gave them that parcel of land to live and develop from, and it's called Seisha. So we look after one another, but nobody's looking after us.
But the problem, one of the problems, that's a lovely sort of partnership, but one of the things is they still feel the need to look after country that's being gradually covered over with water, and
That's home.
it's very difficult to watch that happen. I mean,
It's-
some of the things that I've noticed is that people are using international mechanisms which can be helpful, you know, making complaints to UN special rapporteurs for Indigenous people or human rights and environment. So you can't overuse that, I suppose, because they've got a lot of things to do, but they are mechanisms that people can use. So having people like Donna, Michelle and I and countless other people in the audience who I know are very generous and give their time and knowledge is we're all willing to help people. So connecting is pretty powerful. So,
you know, then they talk about these volumes of water, and I come back to that thinking spatially and temporally and thinking in systems. I can remember saying to my grandfather, telling me there's two conversations. One, he was never allowed to go into the river systems with any animal fat or body paint on his person for fear of upsetting the ecological cycle. And the second conversation I had with him was when I first, forgive the pun, waded into the water industry. And I asked him, I said, how many megalitres does the guada need out here to be functional? He said, what's that? This language, this water speak, right? I said, it's a volume of water. He said, I don't know about volumes. He said, but when the water's at that level on the riverbank, we're all happy. And you know, there are studies at Burke and Brewarren that when the Barker is flowing all the way through, even down to Menindee, juvenile crime, domestic violence, and other incidences within the Aboriginal community go bang.
You know, another way of looking at this is there's a very powerful YouTube clip I've just sent to Judith about Jimanote, who's a Zuni expert, a wonderful, wonderful guy. But for many years, he's been doing a project on Indian mapping. It's three-dimensional mapping and storytelling, but basically saying we are not going to play that language game and we're not going to play your conceptual language. This is how we think of place. And it's the most extraordinarily powerful thing. It's an art form. It's a way of preserving knowledge, but it's also a way of saying that we're not going to think of water this way.
Yeah, well, obviously,
I said it to you.
colonial mapping
Jimanote's fabulous.
was a way of controlling. So the fact that people take that tool back and use it themselves is a great improvement.
Can I be bold? Yeah, I'm bold all the time. One of the things I would like to see Michelle and the NELA group to come out of this is a partnership with Indigenous Australia, or a statement that we can walk, talk, learn and achieve together. I think I know I've been doing a lot of talk, that's my fault, but to listen to the lack of resources, but then the wealth of knowledge about one's own country. I think that NELA does have a role to play, and it shouldn't be dissuaded from exploring on how we can be better together.
Or, I mean, I think your experience is the classic example about all these laws, and like there are about 1,000 environmental laws on the books, and it hasn't addressed those basic flaws in the system. You know, culturally inappropriate, lack of timing, lack of resources. You know, advertising EISs in, you know, putting them on display on Christmas Eve. You know, expecting people to access 10 volumes and respond in 28 days. All this extra law hasn't helped. In fact, it's probably made things worse.
Because you feel like you've got a possible.
You're overwhelmed.
It is, it's overwhelming. It is.
Yeah. I know that we've all been talking too much. Would you like to say something else?
No, I don't think so. I don't think so. I just feel, we feel very, I don't know, disempowered.
Isolated.
Yeah.
The whole process is just horrible.
I'll give you this commitment from me. If you need me, I'll give you my card, you ring me.
I will.
I'll come and sit on your country.
Yeah.
I'll come and have a yarn with you. And if there's anything I can do to help, you have that commitment in spades.
Thank you. I'm sure we'll be ringing.
I hope you do. I hope you do. And I hope that some NELA, some really key and groovy NELA people get on that bus with me to go for a drive.
It's just horrible. It's just like, I don't know, it's just like we don't exist, isn't it?
I've got to say, you're absolutely right. And when I talked to you about what this was like at the start, Mum was the one that just like not discovered, but you know, realised what was happening before I did, and she made the connection with the other NGOs that we're working with. But when we were sitting by ourselves at that early stage, before we had met with anyone else, we were both just looking at it like this is this huge immovable thing. We did not have the tools to deal with it, and I don't know how we would have done it. I still don't know how we're doing it. Because the attitude is that we're making it difficult. Even at those early meetings, people were coming into it, and I'm saying RAPs were coming into that meeting and saying, we know this is going to go ahead, we're just going to try to minimise the damage and see what could be done. We were never going to take it lying down, but that defeated attitude from the first moment really shows that this is an issue everywhere. We're all coming up against the same problems.
And I've got to say, this whole project is for development. This is for no other reason but so they can develop downstream. It's not going to supply extra water for Sydney. It's not going to do anything for anyone other than development.
It's going to flood, it's going to flood.
That's right. And we don't have issues with flood mitigation. There's a lot of other avenues that they could go down, and that's the problem is those other avenues don't mean that they can't develop. And so we're all for flood mitigation, but we're not for this. We're not for the raising of the wall. You know, there's alternatives, and we want them to look at that. So, yeah.
It's hard to explain to people why this matters so much apart from the ecological impact, because the Gundungurra people are so small now that they think that because they're hidden behind a wall and you can't see our country, that it's all right for them to destroy it because there's no tourism in it.
We lost 80% of sites the first time the dam went up.
And that was, when was that constructed? In the
1961 it finished.
a consideration, not even a twinkle of the eye.
No, nothing. There was no EIS. There's a few people went down there and thought,
Like
oh, look, this is really
thing.
important. I'm going to take some photos. And they were just normal people, and that's really the only records that we have of what's there, what was there.
And there's another thing I'd like to add from a cultural perspective, and just listening to mother and daughter talk. Again, it's not new. It's something that I've been taught by my mother and my grandmother, is that a lot of the women, Aboriginal women, are the water knowledge keepers. They are the ones that have, and I don't know any of the stories, right? Because I'm not a woman. But number two, but the most important is, I respect the fact that in a lot of our nations, a lot of our clans, women are the knowledge keepers around water. And their voices seem to be marginalised to have the opportunity to influence and make decisions. And I'd like to see, and well, being the father of 4 daughters, I'm profoundly committed to making sure that if my voice can be any help to changing that dynamic, then I'll be a champion for our women to be heard louder, stronger and prouder.
And I think we've got to recognise the enormous effort you guys have made. You know,
Thank
it's
you.
just, you know, it's not just the knowledge and the expertise, it's that commitment of your heart and soul and time.
I would like to add though, this is a World Heritage listed area, and they changed the Act last year to be able to flood this area. Now, this could set a precedent for other, you know, listed areas all over the country. You know, if they can do that to us, what can they do to the reef if they feel like they can?
Well,
You know,
UNESCO might have something to say about that.
well, they've had something to say about this too, but it's just not getting through to the government. They're just ignoring it.
Which is why maybe appealing to UN special rapporteurs may assist. It might, you know, they've got a lot to do, so it's worth thinking about.
If we're going to go there in World Heritage, I think there's a real problem with the World Heritage listing for cultural values that are determined by non-Indigenous experts.
We have that problem too.
I mean, our cultural values didn't even make it into the World Heritage listing, but that was because of lack of time. They didn't have the time.
Kakadu
to do it.
Stage 3 was a huge dispute involving IUCN, World Conservation Union. And, you know, who should determine the cultural values if the cultural values are Aboriginal?
Well, I just want to tell a little yarn. So this connection, right? We connected through culture, but we're connected too. As Aboriginal and non-Aboriginal people, I use the salad bowl effect. The glass bowl represents the community, right? It's transparent, we move in it, we live in it every day. And each of the vegetables that go in that make that salad can represent the different dynamics of the cultural diversity within our communities, but each maintain their authenticity through colour and flavour, which can be translated into religious beliefs, choice, practice, way of life. What's the common binding ingredient? The salad dressing. And what does that represent? The basic ethics that my parents instilled into me to be a good person, to be a hard worker, be a good friend. That's our connector. That's our connector. And culture and the two-way learning can bring us even stronger together. But we've already got a fundamental platform to connect, to be better together. Sorry, I just wanted to throw that in there.
So Michelle,
Sorry.
I think we've gone over a bit. The audience has gone home.
We still have 25 people. You're keeping everyone engaged.
Anybody got any questions?
25 still here.
25 people still here, but I think it's probably, on that note, and picking up on your challenge to us as NELA, people are really engaged here, but what's the next step? So I think probably a good place to end is thinking about how as an organisation, how as individuals, we pick up on that challenge to walk, talk, learn and achieve together, which were your words. And I think that's something really important for the organisation to take forward, but something individually to think about and everybody listening as well. So
Can we have an on-country classroom gathering? Can NELA help organise that with these two beautiful women?
And I think it's also wrong to characterise this journey as being tough. In fact, it can be magical. You're dealing with different kinds of knowledges, different kinds of relationships, seeing parts of country through new eyes and new lenses.
New languages. So I would like to thank NELA for this opportunity to invite my friends to come along and inform and educate us.
thank you, everyone. It's been wonderful. And thank you to our wonderful panel of exciting speakers. Thank you so much.
Thank you.
Thank you, Judith.
Marabou and Yane. You got muddy water country up there. Look.